Can you guys see that?
Yes, can see it fine. So the ARC of Massachusetts gratefully recognizes the following members of our agency sponsorship program for their support. Without the support of these organizations, would not be able to run our education series. So thank you very much. And now I hand it over to Michael Andrade.
So, of course, my screen doesn't want to do it the way I want it to, but hang on, let me just see. Can you see the change in slide?
Yes.
All right, then that worked. Great. Love when technology works. Well, hi, everybody. Thank you for coming, and hopefully you find the information helpful. Just one disclaimer, I am not a lawyer, and I am not here to tell you all these legal jargon tools and to navigate all these different pieces. I'm a social worker, and I realize that there's all this legal jargon and all these different things and pathways, and people sometimes get caught up in the legal jargon and don't even know where to start. So my hope is to, even though I'll talk about some legal terminology just to give you context, my goal is to break things down in a way that makes sense. And if nothing else, give you a better sense of the differences and where to begin or where to change as you continue down this path. Um, Right now, there's lots of uncertainty. We know that the House has just issued their version of the budget at the federal level, and the Senate is now looking at the same considerations relative to changes to Medicaid. I wish I had the answers as to what's going to happen, but as we go through this process, we continue leveraging different tools towards navigating and helping support people with disabilities and their families, recognizing the legacy needs. How do we ensure that there are adequate funds, both for support, but also resources that are protected towards ensuring that people have access to supplemental needs for the future? So when you think about the context of what I'm going to talk about today, it's really talking about these different tools and ensuring that these tools are available towards helping support your loved ones for the future. So I'm going to just begin to jump in. And again, and thank you, Jackie, for the nice introduction. As I referenced before, feel free to then put questions in the chat. I'll stop kind of going along the way at different key points and help address any of those questions that I can. But again, part of this is looking at the differences. There's lots of different options out there. Even the title, Special Needs Trust, there's a range of different special needs trusts. And then throw into that this whole thing called ABLE accounts. And how does it all work? And what's the best option for you and your loved ones? And where do you begin kind of navigating those different pieces? So my hope is that by the end of this session, you'll have a better place or better understanding of where to start, or perhaps help break down a little bit of misinformation you may have heard along the way, and just raise your body of knowledge towards identifying the future tools that are good for you and your family situation. Just to provide some context, the history of special needs trust, it was the ARC of the United States that was instrumental in ensuring that through a Budget Reconciliation Act, that there was protections put at the federal level towards being able to safeguard assets. Because prior to these rules, the reality was that the asset limits that we still deal with today that are still restricted to 1987 rules of $2,000 for Social Security and Mass Health limited people from being able to put any funds away. So part of what this act helped establish is a range of different trusts towards being able to have folks be able to set aside funds and not disqualify them, but with caveats in terms of certain rules. So I'll get into different aspects of the different types of the trusts and the key differences between them. But at the end of the day, what all of these things I'm talking about today is around leveraging assets to maximize benefits. So the goal is to be able to then legally put funds aside towards not impacting Mass Health, Medicaid benefits, and or Social Security benefits. And there are legal tools to do that. And that's what we'll be engaging today, as well as talking a little bit more about ABLE accounts and that's a new tool towards ensuring that folks can understand how to navigate, and my recommendations as to how to approach the ABLE accounts, especially if you're looking to leverage trust tools. As I mentioned before, right now, in terms of qualifying for public benefits, even though the ARC of the United States has advocated for an increase in the resource level, the $2,000 limit remains. And we are advocating for that limit to be raised up to $10,000. But unfortunately, as of this time, what happens is if a person does have a back payment or they bring in more than they have $2,000 in allocation in their savings account, they will have a payback to Social Security. And that would then impact their ability to remain on Medicaid, which is Mass Health. So part of that is these tools are here towards helping us leverage them, towards making sure that we can help approach folks, towards making sure that they have available funds for supplemental needs. And that's a key word I want to make sure people understand. Trusts, they don't just say, hey, take this money and you can have it for anything you want. There are key aspects of supplemental needs. And trusts have key provisions as to what is allowed and what's not allowed. In trusts, the big areas that funds cannot be used is for housing and or food for folks that are on SSI. And the reason for that is that folks on SSI, when they receive their monthly payment, the Social Security Administration calculates that part of what that payment entails. Now, whether it's enough or not, I'm not here to argue that. Of course, I would say it's not. But the reality is Social Security says we're giving people money for food and housing. So that's why when folks put funds into a supplemental needs trust, that funds can't be used for those kind of things for folks on SSI, because SSI could then take that income. So that person got money for housing. They'd say, well, that money, we already gave it to you, so we're going to take it back. So hence why that rule applies for folks on SSI. The ABLE accounts, there is an exception, but we'll talk a little bit more about that as we go. So when you think about special needs trusts, the path in terms of kind of which way to navigate and where you begin first looking at, okay, what is the age of the individual? Because the age has a key factor. For folks, so for a D4A trust, that's a self-settled trust. That means I, Michael Andrade, ended up receiving funds in my possession. I have a disability. Before the age of 65, I am entitled to do what's called a self-settled trust. That means I can go to a lawyer and I can have a specialty trust established just for me that says the Michael Andrade Supplemental Needs Trust. And I can then put as much money as I want into that trust, so it won't hurt my benefits. But they have to be used for supplemental needs only. It needs to be an irrevocable trust. And the control needs to rely with someone else. It can be a family member. It can be an organization like the ARC. It's that key element of control that allows for the qualification towards the trust being viable. If folks are 65 and older, Medicaid does not allow for an individualized trust under a D4A. That means that at that point, the only other tool that folks have is what's called a pool trust. And that's when a nonprofit organization like the ARC of Bristol County and the ARC of Berkshire County, and there are two other trust corporations in Massachusetts operate a pool trust, they have to be a 501c3 charity and towards helping support the people with supplemental needs. I'll get into the key aspects of the differences, but let me just kind of stop here because I see this.
Yeah, we do actually have a couple of questions
in the chat. So let me stop here and let me answer a few of these questions. So Jackie, if you want to walk me through them.
Okay, so John asks, if a beneficiary is receiving DAC SSDI, not SSI, can the trust funds be used for housing?
Yes, I believe. Actually, DAC, can you just explain that to me?
John, do you want to unmute? I'm not sure what DAC is either, but if you receive, go ahead.
Of the adult,
Yeah,
the parent.
disabled adult child benefit that's based on the parent's social security.
So I'm sorry, the answer to that is my understanding is yes, it would still qualify and they would not be able to use it because that calculation is still factoring in food and housing. It doesn't
We
make a
have,
difference if it's drawing off the parent or the individual. I believe Social Security would still see that. It's a question to ask them for to clarity, because I have not specifically asked that question, but recognizing that the SSI calculation would still factor in food and housing, I would err on the side of caution and assume it is included.
we have a number of questions about the ABLE account, but I know you're going to cover that later. Do you want to wait till we get to those slides?
I can address some of them now if they want.
All right, so for the ABLE account, is there a total limit of money that can be deposited? Is there a limit of the annual amount that can be deposited? And does that apply the same to SSDI?
Yep. So at the end, you'll see that there's slides. So right now, there is a yearly limit of $19,000 that can be put. That limit may change each year. Right now, when it started off where we were doing $14,000, and every year we've been able to see an adjustment. The current maximum that's allowed to be put into an ABLE account is $100,000 in terms of qualification. So in other words, if a person puts $19,000 a year up to $100,000, Social Security and Mass Health don't qualify those funds, but anything over $100,000 does then count towards asset implications. And then every ABLE account has a max amount that you can have in those funds. So you'd have to look at each state because every state has an ABLE account.
And then does that apply the same to SSDI?
So SSDI is different. So SSDI is not asset based. So you don't need to, you can have as much money as you want on SSDI is different in the sense that it looks at in terms of ability to work. So if it's earned income, SSDI may be impacted if the person has more than 9 earned months in terms of qualifying income. But as far as the asset limit, SSI doesn't, they don't look at how much money you have. But the key trick here is then if the person's on Mass Health, you then need to look at that asset limit. So it's not SSDI, it's the asset limit relative to Mass Health if the person is receiving Mass Health.
Again, some specifics about the ABLE account. Is it taxed?
Nope. So right now it is tax free. So any earnings that are applied in the ABLE account right now, because they're invested. So what happens is people, when they choose an ABLE account, they will then choose what level of investment they want. And then those tax earnings are tax deferred.
Can you transfer all 529 money into the ABLE account? And would that, if that's allowed, would it be taxed?
So within limits, and it would not be taxed. So in other words, if it's the $19,000 limit per year, you can only transfer the maximum obligation within that.
What qualifications are needed to open an ABLE account?
So right now, the onset of disability needs to be before the age of 46. Again, that number is changing. A few years ago, was the onset of disability was the age of 26. So as we at the federal level, we continue to ask for additional changes. Our intent was originally to actually have ABLE accounts have no age limit and have no yearly cap. But because they modified it, someone referenced the 529. So the way it's structured is the ABLE account is designed after the college savings plan. So it was the idea that people with disabilities would jump onto the IRS code towards being able to then have their own accounts, but the design of it is very much similarly towards the college savings account under the IRS standard. So traditionally, when those limits go up, we see the ABLE account limits go up as well.
I think we can keep going.
Okay, perfect. So as I'm going to go shift back, so special needs trusts, and again, I'll spend a little bit of time on this because this is where a lot of folks, special needs trusts, you don't need your own attorney. Most of the actual, I'm sorry, special needs pool trust. So there are 4 nonprofit organizations in Massachusetts that then provide this service, and it's this notion where folks don't need to be able to then actually have their own separate trust. So the idea that here I am, Michael Andrade, and I want to be able to then put funds into a pool trust, but instead of me actually contacting a lawyer and paying the $2,000 to $3,000 to have a specialty trust just for myself, I would go to a pool trust. And then what happens is there's a master trust agreement that's established amongst all the trusts. And what happens is through what we call a joinder agreement, the individual comes to that. So all the standards of the trust have already been approved by Medicaid. And it allows the person to then, whatever assets that they may have that are disqualifying them or potentially disqualifying them, they can enter through this joinder agreement towards being able to then move those funds under supplemental needs and no longer have an adverse impact towards public benefits. There's also a third-party pool trust where families can, instead of going to their own attorney and drafting their own pool trust, they can enter it through a third party. So when I say first party or self-settled, those are terms when I'm the person with a disability. So the money now is in my hands, and I need to be able to take them out of my control towards qualifying for the public benefit. Third party means someone else, whether it be a parent, a friend, a relative, they want to be able to set aside money for supplemental needs trust for the future. And they want to be able to put those funds in an account without having to go through a specialized attorney. They can do that through one of the pool trust agencies. One of the key differences between those two, and I'll talk a little bit further about the ABLE account, is that for first settled or self-settled trusts, there is what's called a Medicaid payback. So the Medicaid says, we're going to let you put this money aside. And for your supplemental needs, you're going to be able to purchase clothes, purchase furniture, go on vacations, do those kind of things. But when you pass, we're going to put in a claim toward your estate should any money be left. And what happens there is at that point, then if there's additional funds that are left after you pay back Medicaid, then any additional funds would go to your beneficiaries. But oftentimes there's not, because the Medicaid claim surpasses what's in the account. So the state gets those funds back. A third-party pool trust does not have a Medicaid payback. So I think that's a key distinction for people to understand, because sometimes people are thinking, oh, I want to put some money in his trust. Well, you got to make sure what kind of trust is it? Because if it's a first settled, the last thing you want to do is put funds in that trust because there's a Medicaid payback. So you can establish a third-party trust, whether through the pool, through a pooled option or through an individual trustee relationship. So third party becomes very important, because third party means someone else holds those funds, and the rules relative to Medicaid payback doesn't apply. But if it's first party or self-settled, that's when those funds have, and that's because that first party is the person, or the self-settlement, right? It's the funds that I've had that are getting put into that account. That's what's subject to Medicaid payback. So part of that is understanding kind of those key differences. And the ABLE accounts also have a Medicaid payback. So it's important to note that if in fact the ABLE accounts will talk about the fact that people want to make donations into the ABLE account. And that's certainly fine if folks want to do that. But I want people to understand that if you decide to put funds into someone's ABLE account, you don't have the restriction that your funds are out of that payback. Whatever funds are in the ABLE account, they will be subject to Medicaid payback. And if that Medicaid claim is beyond what is in the person's account, well, then those funds will not get passed on to beneficiaries. That's something that sometimes people don't understand. So I highly recommend that if folks are looking with their own funds, not the person with a disability, and you're looking to set up a supplemental needs trust, look at either creating a third-party supplemental needs trust or a third-party pooled supplemental needs trust, because that way those funds are protected and they will not be subject to Medicaid payback requirements.
Can you explain a little bit what you mean. What exactly is Medicaid payback?
So I'll just use simple numbers. So let's say I have my own supplemental needs trust, self-settled first party. So I went ahead and I opened up a trust. And where the money came from is someone left me $100,000, my grandmother, and I had to put it into that account. So let's say that the next year I pass. Well, because it's first settled, we then have to report that to Medicaid. We have to tell Medicaid that the person has passed. And what Medicaid does is they send a bill. They say, for the past year that this person's been on our Medicaid, we've spent $200,000 on their care. So now, if the account only has $100,000 and the Medicaid payback is $200,000, well, then whatever we have, we would have to pay to Medicaid, and there's nothing left for beneficiaries. Now, sometimes it's the flip that happens. That person has $200,000 in their account, and Medicaid sends a bill for only $100,000. Then the first $100,000 gets paid to Medicaid, and then the other $100,000 would be paid out to beneficiaries. A lot of folks don't understand that sometimes, unless it's third party. So again, back to that piece. If the money has come to me in my possession, my only option is to do what's called a self-settled trust. I can go to a lawyer and I can have one set up, or I can enter a pool trust. So long as, if I'm over 65, my only option is to do a pool trust. But the federal government says, well, wait a minute, we'll let you put the money in here for now so that you can use it for your supplemental needs. But upon your death, we're going to be one of the first ones in line to be able to basically get back what we may have put out on your behalf. Does that make sense?
Yeah. Can I ask a few more questions? We've got a
Sure,
bunch coming in.
sure.
Okay. So would a third-party pool trust affect the disabled person's SSI benefits?
No, because the third party, no, because that's not, it was never theirs. So as long as the third party pool trust, if the person's on SSI, if you're giving any money for housing, or if you're giving any money for food, you just need to be careful with that, because SSI could calculate that as an asset and they would just readjust their portion. So my recommendation in those situations is, as long as they're not on SSI, it's fine for housing, food, and any other kind of supplemental needs. But if the person's on SSI, that rule still applies towards making sure that you're protecting those assets.
Can an individual have a pool trust and a special needs trust? Two different trusts.
Yes, so basically the person can have, if the person has a pool trust, but let's say they have a third party supplemental needs trust, that's perfectly fine. If you have a pool trust, part of that is understanding kind of what it is, why would you need more than two? Traditionally, you would have one trust that would kind of be the catch-all, unless it's a third-party trust. So for example, in the example I gave, I can have my money, if money comes to me, I can have my own trust, and then I can have a third-party trust for my benefit that my parents or my sister or my brother established on my behalf. That makes sense? So you can have varied trusts. Part of that is making sure that in terms of the distinction in terms of the ownership and the type. Any other questions, Jack, or should I continue?
Yeah, there's a lot in here. Does the ARC provide counseling, non-legal assistance in navigating SSDI mass health applications? Is that something that the ARC would help with?
Through most local DDS family support centers can provide that support. So if anyone's struggling with those kind of questions, I'd recommend that. So the ARC does have a family support center that we support folks in the Attleboro Taunton area, but the DDS family support centers tend to provide those supports.
What is meant by the irrevocable trust can't be changed?
So once you put the keyword irrevocable, so that means I open up the trust, I put the funds in, and then I go, I really wish I hadn't done that. Well, irrevocable means there's no going back. Once you've done it, there are other kind of trusts. So Other trusts that don't fall under special needs provisions, they may be revocable. But in this type of situation, once you establish it, there's no going back.
Which is better for the child, a 529 or the ABLE account?
So again, part of that is that's a decision each person has to make. If the person is looking to go to college, then you'd be looking at the 529. But the ABLE account provides more flexibility in the sense of disability related expenses. So it's a
Do you
lot more
need to
global in terms of the ABLE accounts versus the 529 that's specifically focused on college education.
college, right? And do you need to secure an attorney to set up these accounts?
So as far as opening up a pool trust, no. Most of the organizations that are pool trust vendors, including New York and Bristol County, you do not, they have trust counsel that guide you through the process. But if you want to then establish your own supplemental special needs trust, whether it be a first party or third party, then yes, you would need an attorney to help you guide you through that process to put together the different documents. And as I referenced, it can be as anywhere between $2,000 to $4,000 that you can then work with an attorney towards building. And then there's some nuances you can build in as we approach different supplemental needs trusts.
What if someone sets up an ABLE account, then when the parents pass away and they set up a special needs trust, can you have both ABLE and special needs?
Absolutely, absolutely. So if in that situation, you'd want to have the parents actually establish a third party pool trust. And even if it may be a non-active trust in terms of maybe active when they pass away in terms of assets going in afterwards, but then it made sure that the funds are third party and they were never in the control of the individual, thereby not disqualifying them from Medicaid or Social Security benefits. And we're seeing, and in some cases, people have a trust and they want to be able to shift funds over into an ABLE account, and that is allowed as well.
Can funds be moved or transferred from an ABLE account or an OBRA 93A trust into a pool trust?
So in those situations, the question there is you've just paid for something that's very individualized. Why would you want to shift it to a pool trust? So again, that I need more specifics. It can be done. We'd have to understand why and what's the logic and before. Does it make sense?
If SNT is funded prior to the death of the parents, do you have to file a tax return on the trust?
So if they're funded, so if any trusts are actually funded, when they're funded, they are going to have, depending on how much money is in it, they qualify for taxes, the trustee would take care of those tax filings. So if it's a nonprofit organization, they would manage those different pieces. But if it has any earnings, then at that point it would need to qualify towards meeting the threshold of tax filings, and you'd have to work with a local accountant towards making sure that those funds are being allocated appropriately.
As a parent of two disabled adults, a special needs trust was set up years ago for when my husband and I pass. Is this still the best route, as we would have another adult child in charge of this? What would the benefit of a pool trust be?
So if the trust already exists, instead of going to a pool trust, you can certainly talk with your other child if they're the trustee, but then try to look at whether or not they are ready to be the trustee, or you want to partner with an organization that provides specialty services, such as the ARCs, in terms of providing special needs trust navigation and support. I explain it this way. I have lots of family members that I want to be brother, I want to be cousin, I want to be a support to. I'm not sure I want to be their trustee. I'm not sure I want to be their rep A. I'm not sure I have the expertise. Fortunately, in my job, I do, but most people don't. So part of that is then kind of figuring out, okay, we just assume that they're going to do it. They may not be comfortable with it. So part of that is engage with them, talk with them, because there's a whole range of things that are required if you're going to be a trustee. And that means they have to be willing to do it and be willing to then be taught the latest guidance and practices towards making sure that they're being able to fulfill those obligations. Some families have decided that they've wanted so even if you have a trust and you've said, oh my God, I named Michael, now I want to change it to the ARC, that there's a mechanism to do that. So it's going back to the attorney and saying, hey, I want to relook at this. I think I want to change my successor trustee. That does not require you to do a complete new trust. It simply requires an instrument of change document.
So I know we need to get through the slides. I'll ask one more question, then I'll go back to your slides. What if you're on SSDI and you have a non-funded special needs trust established by your parents? It doesn't get funded until they pass. How does this affect services, housing, Medicaid?
Nothing, because right now there's no money in it and it's on SSDI. So until it's funded, it's not going to affect SSDI. If the person is on Mass Health, they would want to make sure that because it's a third party trust, it was never in their possession. So the key thing there is they want to make sure the funds never get paid out in their name, so as to be perceived as an asset. So that person, they want to go shopping. Well, they'd want to make sure that they use those funds to be able to pay the vendor directly. So in this case, if there's a credit card, they'd want to pay it directly to the credit card. They want to just make sure that those funds for Mass Health purposes aren't being written out to them. So for example, I'm an SSDI, I'm on Mass Health, I need a new couch. Well, I'm going to make sure that that trust is paying directly to Cardi's or to Jordan's, so as to not have a check in my name that could be perceived by Mass Health as income to me.
Okay.
All right, let me cover a few more slides and we'll continue covering some of the questions. So some of the things I've already addressed. As I mentioned, the ARC of Bristol County, how all of the different master trusts work. People hear the word pooled, and I just want to be clear that people don't understand that they understand that they think pool and it's like, oh, we just take everybody's money, we shove it, we put it together, and it's a free for all. Well, that's not how the way the pool trusts work. They're invested. The word pooled is pooled for investment purposes. So whether they're done collectively or they're actually in one master account and everyone has a prorated ownership, the way that the ARC of Bristol County does it is that everyone still has a sub account. So everybody's money is their money. The idea of pooled is pooled for investment purposes, and they're pooled in the sense that people come through a master trust agreement. So they're not doing individual trusts. So when you think about a pool trust, there's this notion called a trust protector or a trust advisor. Those provisions are not allowable in a pool trust. That doesn't mean that the pool trust is not going to talk to people and their people's families, but when you're thinking about actually creating your own supplemental needs trust, part of that is you have these options. You can actually specify that you want to have a trust advisor, this person that is going to, so in the example that we heard earlier of someone's family member, some people say, I'm going to put Michael as a trust advisor because I want to make sure that the trust knows that I want them to talk to this person. They also have this approach called the trust protector. That means nothing comes out of the trust without this person approving it. So you still have the trustee, but somebody else is making sure that those funds are being protected. Those key elements are not available specifically for a pool trust. Part of the different aspects and kind of these individual trusts I referenced here, sometimes, many times, as we look at some of the key elements and some of the key benefits, is that, as I referenced before, it's all about protecting assets, but it's also, when you think about the individual pool trusts, they're less money to establish because many times they're anywhere between $500 to $700 that the pool trust organizations are setting up. And there's less management because from their end, part of that is they're very streamlined in terms of processes. There's no direct nuance that you can establish in a specific individual trust. One of the key elements about the pool trusts is that the charitable remainder. So what happens about the pool trusts is that Medicaid says, okay, well, here's this money that's owed, but the nonprofit organizations that operate the pool trusts are entitled to keep remainder amounts. And those remainder amounts help promote those charitable purposes. So, for example, in the event that someone passes and the ARC has been a trustee, then there's amounts in terms that the organization is allowed towards using for legacy purposes. So part of our mission and the way how we approach the remainder accounts is towards supporting advocacy, supporting other people, guiding them relative to these services, and being able to help address and maximize their key benefits. Just gonna, because again, a lot of these things I've already covered in terms of the different pieces. I do, because I'm mindful of time. I know there were lots of different questions, but this pretty much walks just in terms of the different disbursements or protections, the processes that any kind of approaches as you approach pool trusts, even supplemental needs trusts, making sure all the requirements and ensuring that you have oversight and segregation of duties and protections of all levels towards ensuring that funds are appropriately managed and protected. All right. Able accounts, because I know there were lots of questions. Let me just kind of cover there. Again, one of the key elements about these accounts is that there's this notion called qualified disability expenses. So we wrote this in such a way at the federal level, and again, I say we, the Arc of the United States was the key sponsor of this particular legislation, to this time include, and if you notice in my presentation, food and housing are here. So part of this, we knew the challenges we had with the OBRA legislation and the restrictions and the interpretation of Social Security. So the ABLE account and how we designed it was to create this definition of qualified disability expenses that was so broad that in essence, it pretty much covers, we believe, 99% of the different things that people may need. And it specifically referenced language around ensuring that we had funds available for food and housing. So as you approach thinking about the ABLE account, in Massachusetts, and again, every state has one, so you can open up an ABLE account in any state. Part of this is here in Massachusetts, there's Fidelity Investments, they call it the Attainable Plan. And here, part of that is you can set it up online. You can set it up for as little as $50 and build from there. But again, my recommendation here is not using third-party assets for these accounts because there's a Medicaid payback. If you're interested in doing third-party assets, my suggestion is you explore a third-party trust. If it's a small amount and kind of builds, you could look at a third-party pool trust. But a third-party trust, if you want to ensure that you have that peace of mind, when we're gone, we want to make sure that there's the set-aside funds that are protected. Then from there, you want to look at a third party. But let's say the individual has a Social Security payback. Let's say the individual has too much money in their savings account. Part of this is opening up an ABLE account towards decreasing the asset. And again, it can stay in that account as long as the person is alive, as long as it meets these kind of key thresholds. So the key threshold here is right now, and again, it changes, is $19,000 a year. So you can put in 100 this month, you can do 1,000 next month, or start with 100 and you leave it there in terms of then needing those different funds. Every ABLE account will have different rules as to how to access funds. But as I referenced before, they provide federal tax benefits. So some states do tax, Massachusetts does not, but there are some states. So part of that is just ensuring you understand what are the actual key elements of each state if there are any kind of tax obligations. And again, the funds are being managed by Fidelity. So they're being invested with the notion of being able to grow in a moderate portfolio towards being able to then provide additional funds for the future for that individual. So that $100 could be $150 by next year. The idea is that it's being invested in an approach towards helping kind of build those funds for the future, similar to College 29 and other kind of investment tools. In terms of work aspects, there are additional pieces that each ABLE account will reference in terms of additional earnings. So typically it's almost up to $30,000. Can't remember the exact number off the top of my head because it just changed as of January. But part of that is kind of if the person is working and their earnings are disqualifying them from Mass Health, well, then they can put in additional funds towards being able to address some of these key components. Again, I just want to emphasize part of the age piece here. Again, onset of disability has to be 46. So we've worked with some folks when they may have had a acquired brain injury that happened later in life. As of this time, they're not eligible for able account. So the pool trust, if there would be a consideration for them, or if they're under the age of 65, but yet over 46, then we still consider a special needs trust. That would be a self-settled trust towards supporting them. What I've done at the ends, and again, I've kind of walked you through the different approaches just to kind of, at the end of the day, it's about making sure that those funds are being protected and they're still accessible for supplemental needs and addressing the various approaches and needs that people have, but they're also legally addressing the different pieces. So some of these questions came up is, this comparison chart. Able, what are the key elements around eligibility? Pool trust, supplemental needs trust, first party, special needs trust, third party. So I've kind of walked you through to kind of navigate you the different options. One of the key differences, as I mentioned earlier, you can have different trust accounts, whether or not they make sense. That's up in terms of trying to understand the motivation behind them, but you're only allowed one, a person's only allowed one able account. So being mindful that you can't just open up an able account thinking, oh, it's $19,000. I'll open one here in Massachusetts and I'll go to Rhode Island and open another one. That's not allowed. Part of that is the federal government said that's the most they're going to do. So they're only allowing you one able account. Whereas trust, you can have different types of trust depending on what it is. As I referenced before, for first party, the key element is it has to be before the age of 65 approaching. Otherwise, the pool trust, there is no limitation. But let me stop there because I'm mindful of time and I don't know how many other chat questions we have, Jackie.
We have quite a few, and I think we'll cover a couple more, but we're also going to take all the questions and try to do some short answers afterwards that we can send out to everybody.
Perfect.
I just kind of lost my place. Oh, if the third party accounts are
Stop
pooled,
share.
how do we know the funds are being used best for my child?
Say that again.
If the third party accounts are pooled, how do we know the funds are being used best for my child?
So the third card, so again, if you're talking about a third party pool trust, that the intended purpose still has to be tied to that person. So that individual, your child, they'd be submitting a request for out of their sub account. So it's still their money. You would be working with a trustee towards that they'd be submitting to ensure that whatever it is that they're asking for conforms with trust regulations. So that's the intent. The intent is having, whether you decide to have a family member do it, or you choose a nonprofit or a lawyer's office, that's their responsibility to ensure that that's happening. But they're pooled only for investment purposes. Everyone
Right.
still has their amount of money. So people sometimes get, oh my God, am I going to lose? If I put in $100,000, does my money go to help support Jackie? No, no, no. Your $100,000 is still for your $100,000. It doesn't get borrowed.
What is involved in being the trustee?
So the trustee, part of that is ensuring, again, if it's a supplemental needs trust, the trust document will spell out the responsibilities of what it is that that person is going to be doing. If it's through a pool trust, in the document, I listed the variety of different things that we have to have relative to oversight, compliance reports, tax filings, and ensuring that every year we're paying attention towards trust law because things, as we know, things change.
Right.
Right now, we're paying attention to see if there's going to be any changes to trusts relative to the federal government. The good news is, knock on wood, we haven't seen anything yet. But last year, our pool trusts here in Massachusetts were outlawed for anyone over the age of 65. We, fortunately, from an advocacy standpoint, were able to overrule that. And we had legislation where we were successful so that the pool trusts were back on track as of this past May.
Other than able accounts, what is the best way option to set up a gift so it doesn't count against SSI?
So part of that is you can look at a third party, establishing a third party trust or a third party pool trust, because the third party ones are protected because they're your money. They were never put in that person's name. If you put it into the able, there's going to be a Medicaid payback. So creating that supplemental third party trust to me is the best option, whether you do it individually or through a pool trust. that is going to be your biggest safeguard, because those funds will be restricted for supplemental needs only, and they're protected.
So can you simplify the advantage of the third-party pool trust versus setting up supplemental trust for your child established with the lawyer? So just go over that again.
Yep. So the first thing is cost. So one's going to be between five to $700 versus thousands of dollars, because the creating your own individual trust, you're going to have to engage with an attorney, versus a pool trust, you can go through the pool trust without engaging your own attorney. The second is, what are the individual things that you want? Do you want to build in like a trust advisor or a trust protector? If you want those kind of key aspects, that's not to say that a pool trust isn't still responsible. They are, but you can't add those key provisions, because what's happening is everyone's entering into one master trust. You're entering into that, so you don't have the ability to put in the specifications. Where in your own individual trust, you can do that. Those are the key differences as to how to approach them.
Do you tie the third-party trust to the disabled person's name, or does it stay in the name of the person who's funding it, and then you make the disabled individual the beneficiary?
It can be whatever way you want. The disabled person will always be the beneficiary. But if you want to, some people will say, I want it to be the Michael Andre Supplemental Needs Trust. Some people say, I want it to be the Andre Dream Trust. But Michael Andre is the sole beneficiary for his supplemental needs. There's no key elements that you can name it whatever you want. The name doesn't matter. It's what's in kind of the document and the provisions.
I see Kim, you had your hand up, and I know you made a couple of points in the chat. Did you want to take a minute and ask a
Yeah,
question or comment?
I appreciate it. Michael, I just sent you an email as well. I work with New York Life. I'm an agent here in our Johnston, Rhode Island office, but licensed in Mass and Florida as well. And I work with a lot of special needs families to help with planning. And I know, separate from, what everybody seems to think for 529, there's a lot of other vehicles like custom whole life and income annuities that can also be utilized, and it can be used as a way to fund those trusts that you're talking about. What experience have you had in using those type of vehicles?
We worked with several different advisors. Actually, Rich Howard from Bay State Wealth has worked closely with lots of different families. For years, we worked with MetLife, the Met Desk program. So what Kim's talking about, and thank you, Kim, for explaining that, is this is
Absolutely.
where, you're not ready to do anything right now, or you want to buy a life insurance policy and you want the trust to be the beneficiary.
Mhm.
So you can begin to establish that, and the trust is unfunded. It's just kind of holding, it's waiting. And then that way it's another tool towards then being able to then activate it when it's later on. So I absolutely encourage you to talk with different, because again, part of that first step is talking with an attorney, but then also talking with financial advisors to then think about the long range path about how to be able to then make sure that those assets are protected.
And I think a lot of people think they can't do the trust because they don't have the money, and being able to use a life insurance policy gives you the ability to hold it and get it set up the way that you want it, and then the money comes after the fact. So I just want to make sure people are aware of that.
Absolutely. And again, part of that, it also gives people peace of mind that they know
Exactly.
it's resolved. It's there.
Mhm.
And then, when I think that's probably the biggest fears everyone has, is that what happens when I'm gone? And are they going to need anything? So you want to make sure that it's protected. And I can tell you, sadly, the reason that the Ark of Bristol County started doing this kind of work is 20 years ago, we had some terrible, terrible cases of situations that weren't managed properly. And those legacy funds were depleted pretty quickly because the protections weren't put in place.
So can we jump on a few more questions? Thank you,
Sure.
Kim, for bringing that up. Please explain the disbursement process for the ARC's pool trust. Who can request a disbursement and where is that specified? Does the ARC fund manager work with the DDS case manager, a group home provider, and the guardian to determine best proper use of trust funds for benefit of the beneficiary?
Yes, yes, yes. And the person that is, so for everyone that comes into our pool trust, we ask who is going to be the personal representative. Who's the person that you want that's going to be that liaison that's going to request the funds? But then we certainly work with, in some cases, we then work with different nonprofit organizations that are requesting different support. DDS, if the person is involved. Again, we make it very clear that DDS doesn't have control over these funds. And part of that is this is for supplemental needs. So this shouldn't be supplanting their DDS services. But we work with the whole family dynamic in terms of supporting. The one thing that we don't typically do is we don't go to ISP meetings or planning meetings. We have our relationship directly with the person, and we're focused on the financial element, not these other components.
Is there a fee when using a pool trust?
So the way we build it is that the fee is built on 2.7% per year. So whatever the amount that's in there, it's 2.7. But the idea is because if invested, we're actually being able to cover those costs and provide a modest gain.
Could you repeat the names and locations of the 3 or 4 pool trusts in Mass? Because they're nonprofit agencies, right?
Correct. They're all nonprofit. So obviously the Arc of Bristol County, then the Arc of Berkshire County, and they're over in Pittsfield, Massachusetts. We then have Plan of Mass, Rhode Island. They're in Quincy. And then we have Guardian Trust, which is in Andover. And if you Google pool trusts in Massachusetts, there'll be a listing that you'll be able to see. And then they'll also show the distinctions in terms of each one. Obviously, with the 2 ARCs, part of our mission is in terms of fulfilling, helping support people with disabilities. And when you go on their website, you'll be able to see what their focus area is as well.
Did I understand you to say that the local DDS office can help with figuring out what type of trust would be best? I'm looking to set something up for 2 grandsons who are on the autism spectrum.
No, DDS will not provide, originally the question was around benefits counseling and helping support DDS eligibility and application. That would be the Family Support Center funded through DDS. But as far as trying to figure out kind of which path, I would suggest talking with an attorney or talking with a financial advisor towards addressing it. Or my email, I know some people have asked, my email is in the PowerPoint presentation. Feel free to email me, and I'm happy to kind of point you in the right direction.
Is there an option to convert a 529 into an ABLE account, or do we open an ABLE and transfer 529 money to it? My child is 5 and now on Mass Health.
I believe the latter, that you would then transfer the funds.
I'm looking, I don't know if I skipped over somebody's question. Please feel free to raise your hand and ask a question. If I missed, I'm going through the list here. Is the ABLE account the most flexible to use funds?
Right now, yes, because it doesn't have, it allows for disability related expenses to be so broad that it covers housing and food, whereas the trusts do not.
Do you provide guidance? I know there was a question about guidance for people who do a pool trust.
Yes, if folks are interested in pool trust questions, we're happy to address them.
Stephen, you have your hand up.
Yes, it's a question which unfortunately may only affect a small portion of the community, but I happen to be a retired veteran. And I just learned recently that I can arrange in advance so that when I pass, that portion of my pension, which would go for life to my disabled adult son, can be placed directly into a special needs trust, therefore not passing through the individual's hands. Are there any other considerations I should consider?
I would know, as far as that, having that option from there, you can just make sure it's classified as third party. Don't do first party. Any lawyer should know that, but part of that is you want to make sure that it's, because it's your funds, that's not going to affect the person.
Well, so at that point, it's his funds because he is the recipient of the pension.
So that's where you want to talk with an advisor and about how to do that, because it wouldn't necessarily, he doesn't need to be the recipient. It could potentially be the trustee. That's where I would suggest looking into that, because as long as the trustee, that's for his sole benefit, then it doesn't trigger the first party rule.
I'm sorry, could I weigh in on this? Because
Sure.
I'm also a veteran. I've already gone through this process. What he's talking about is a survivor benefit plan, and the funds are in fact they are in the name of the individual who is the beneficiary of the survivor benefit plan. So it does have to be a first party trust. But it goes into a first party. You need to ensure it goes into a first party trust and not directly to the beneficiary, or you're going to compromise their eligibility for your other benefits. So that's something you want to do with DFAS. It can be done after the fact. I just read that your survivors can make that designation after you pass, but it's probably better to get it all set up in advance before, your survivors are going to have lots of other things to worry about.
Okay,
I'm
thank
not
you.
a I'm not a expert on the subject, but the email I received from DFAS, which I'm sure you would recognize that acronym, specifically stated it had to be done before I passed. So I don't know who's right, but I did get a written direction that's why I'm starting to look at creating the trust now and simply having it called for upon my passing.
And again, I recommend do that now because it doesn't hurt to do it, and then that way it's done, and you don't need to worry about it. And there's no, in case there's any potential changes, and then that way and then there's no concern. And again, John, thank you. Part of that is that it's not going to cause a benefit problem, because otherwise, if for some reason that the funds were going directly to him, then it would kick him off. So at this point, self-settled is still better than the funds going in his possession and then having an impact on asset retention.
I see Lucy's been waiting patiently, so we'll go to her while her hand's up. And one quick question before that: does a third-party pool trust need to be funded when it's set up?
No.
Okay, thanks. Lucy?
Yes, two questions. One is there some place where a newly appointed trustee and representative payee could get some guidance or help? Or do you just have to seek that through a private attorney? Or it's something that I think would be so helpful when siblings are being appointed.
So we've been talking with the ARC of Massachusetts about potentially right now support brokers. We're trying to think about building some areas in that. So that's an area that we're hoping in the next few months we're going to be able to provide more guidance in that area, because we realize lots of families need extra help. And unfortunately, we tried getting the ABLE resource centers towards being a more broad support around those areas, and they're not. So I would absolutely.
What resource centers?
ABLE, so the ABLE
the
resource
ABLE.
centers.
Okay.
So we were hoping that, because we said the reality is it's great we're offering this new service, but if you don't have kind of what we call counseling, it's great you have benefits, but if you don't have support, how are people going to be able to navigate this? It's confusing. It's confusing at times for me, because part of this is and again, I work in this every day, so part of that is, so we're trying to figure that out. So please stay tuned. It's an area that we're working on toward trying to add more robust, not just webinars, but provide that level of consultation service.
And then my second question is, as the individual with disabilities is aging, and in some years soon will turn 65, and you've talked a couple of times about 65, something happening at age 65. What is it that we should be preparing for?
So the key element around 65 is that if you don't have a D4A trust established before the age of 65, so again, somebody gave you a person $100,000. Now, after the age of 65, Medicaid and Social Security do not allow you to be able to take those funds and open up your own trust. Your only option is the pool trust. So that's where that year becomes really important, because up to then you have the ability to create your own supplemental needs trust. After that, you're not allowed to. And again, part of that is they look at life determination, and that's the number they defined in terms of being able to then have that eligibility.
So if you already have trusts set up by an attorney, can you add money to it after the age of 65 or not?
So that if you already have the funds, if they're new funds that were self-settled, that's a question I would absolutely ask your attorney, because under the Mass Health legislation, it's changing. I would have told you a year ago that wouldn't be a problem, but with the new guidance we're waiting for, that could be a problem. So I'd be just double checking to ensure that there's been no updated changes, because Mass Health is looking to make changes around any new funds that are coming in.
Great. All right. Thank you.
I know we're over time, so I just quickly want to thank Michael for his time today. Thank our sponsors and all of you for spending your precious time with us. Remind you, please take a few minutes to complete the feedback survey. We're going to try to copy all the questions, make sure we've got answers for all of them. I put the link for our next education webinar, which is going to be what you should know about DDS adult waivers. And that will be on Wednesday, June 25th at 12 p.m. That's the link to register. You can also get it on our website. Thank you so much, Michael. A lot of good information here. We will be following up. As I said, we'll try to get some answers to all the questions as well as get the PowerPoint out to everybody. Thank you and have a great day.
Thank you all.
Bye.
Bye.
Thanks, Mike.
Thanks, Jackie.